Hello, welcome back. GovDoc Breakdown, no opinions, just facts and summaries of government documents, and you take it from there. June 6th, Supreme Court opinion on an order in the case Chambers Smith, Director, Ohio Department of Rehabilitation and Corrections v. Ayers. All right, this one has to do with a woman named Kayla Ayers who was convicted of aggravated arson and child endangerment when she allegedly tried to burn down her father's house. A main fact we need to know here is that Ayers' lawyer did not consult or call an independent expert to refute the state's claims that she started the fire. Instead, the defense lawyer just claimed that her 3-year-old son may have started the fire with a lighter. In 2020, 7 years after the conviction, Ayers filed a federal habeas petition arguing that her trial lawyer was ineffective. Included in the appeal was a 2019 fire expert report that claimed the state's expert in the original trial had serious flaws in his analysis and credentials. So, under federal law 28 U.S. Code 2244 D1A, I love these things, this gives prisoners 1 year to file a federal habeas petition after their conviction becomes final. However, there is an exception in the law if new facts are discovered in the case. The 1 year period starts when the 1 year reset period starts when those new facts could have been discovered with due diligence, basically a restarting of the clock for that 1 year time period. So let's get to the courts, baby. The district court rejected Ayers' petition as too late, but the Sixth Circuit Court of Appeals reversed and allowed the petition, saying that the 2019 expert report was a new factual basis and restarted the 1 year clock at that time. This was appealed to the Supreme Court, but the Supreme Court denied certiorari in the case, meaning they chose not to take it on. And this is where we get to the document today. A statement by Justice Alito on the Supreme Court's decision to deny certiorari. Justice Alito chose to point out that the 2019 report was not really a new fact or piece of evidence, basically saying that adding new support for an old claim doesn't restart the 1 year deadline. You need an actual new fact or piece of evidence in the case. He also outlined that the Supreme Court chose not to review the case because Ayers had already completed her prison sentence, leading to the case not having any practical consequences. But at least Alito issued a stern warning to the lower courts that just because the Supreme Court chose not to take the case does not mean they agree with the Circuit Court's decision to restart the clock based on the 2019 report. But since the Supreme Court did not take the case, the Circuit Court's decision to allow the clock to reset stands. All right, Kaimo, keep your mind open, do your own research, form your own opinion. See you on the next one.